Hi, I'm Debbie Moraes. Once again, welcome to Legal Matters, the program that's been designed to address the critical and sometimes contentious issues that are facing consumers and businesses today. Legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. So the holiday season is upon us. You may be hosting a party or attending a party, having relatives and friends with you. Pay attention. So as the season's upon us, we understand that there are DUIs, people with impaired driving abilities, with or without serious consequences, children enjoying adult beverages, perhaps in your home. Maybe it's even a middle-aged Uncle Ernie. You're liable. I thought today it might be a good idea for us to get a refresher course on that from our lawyers from Odette, Bazar, Grasso law firm in East Providence, Jackie Grasso to my right, and to her right, David Bazar.
Okay.
Okay, so what's the latest in the social host laws? It seems like so many people are super vigilant these days about and taking an active role in the political process about drunk driving or just driving or underage drinking. What's the latest?
Well, there's several different categories we need to break this down to. So let's start by just taking some broad strokes. Civil liability and criminal liability, two different things. So is there civil liability if you host a party at your home and friends come over and get drunk and go out and hurt themselves or someone else? We'll talk about that. Criminal liability. If you have a party, are you criminally liable if someone gets drunk, or are you criminally liable if you serve young children under the age of 21? And then what's the difference between the criminal liability and the civil liability? So where do you want to start?
Let's start with the very popular one about minors and what happens with them. We know in Rhode Island that we've had our own political people having children who've had issues, and there is currently a case that's going on that we'll discuss a little bit later in Charahoe. But with young people who are guests in your home, I guess if you're the parent, you can serve your child a drink, but what happens for you as a social host with young people in the home having adult beverages? Something happens or nothing happens that's serious.
Well, on the criminal
Where's your liability?
There is criminal liability on that side because you're serving alcohol to an underage, to a minor.
Right.
So there's a criminal liability on the civil side.
All right, so
David's-
a couple of different things. The criminal liability, the criminal social host for serving alcohol to a minor, as we remember, there had one point in time in a Barrington case seemed to have been a loophole if they were outside drinking, and this legislature tried to close that loophole and said that if you're knowingly serving someone, or you knew or should know that they're drinking on your property, there could be liability, criminal liability for that action.
And wasn't that specifically whether it was in the house versus outside the house and still on the property? They found that loophole, right?
That's
Maybe
correct.
that's what you're saying. They
And there's a
closed that
distinction.
loophole.
Right, because there was a party, I think it was a keg party
yeah.
or something in Barrington, and the police came, but
Yes.
they couldn't find liability because it was outside. So that loophole was closed. Now, if you want to fast forward a little bit to the case in, is it North Kingston or South Kingston, the Sarah?
Charahoe.
Charahoe.
It's the Charahoe area.
Okay. There's now a challenge to the social hosts law in general on constitutional grounds. That decision hasn't been made. I don't think any court ruling, at least as of right now, has come out to determine whether or not the judge agrees that there's a constitutional problem or not. But the way the statute is written is if somebody allowed minors to drink knowingly, or if they were in a situation where they should have known that children were drinking on their property and they either provided the alcohol or knew that there was alcohol there, that there can be social host criminal liability for that. That's issue number one. On the civil side, in Rhode Island, there is civil liability if a child is allowed to drink on your property and then is injured or injures somebody else. There's a special relationship between you as the owner of the property and being responsible for that child, that underage drinker, and their actions, and what actions it may, if it's foreseeable, they may do to someone else as a result of their being drunk.
Basically, you're just not supposed to serve minors in your home.
No.
However, if it is without consequence, no one's the wiser.
Well, no, you still have criminal liability.
Only if someone catches
Reports
you,
it, yes.
reports it.
Yeah.
And people somehow, even though there are so many stringent standards and so many mad, sad groups and organizations who are trying to affect this process and what's legal, isn't it true that there are still people who say, this is our home, this is our family, and we want to be able to have them have wine. Nothing terrible is going to happen. In fact, they're all sleeping overnight and I'm taking their keys.
I don't think you have the right to make that decision for somebody else's child.
And isn't that the...
And that gets back to the relationship issue that David talked about.
And so you can't decide what laws
Are going to apply.
you want to apply to you and what laws you don't want to apply to you. The law is the law. Now, whether or not the law is written as constitutional, as I said, that determination hasn't been made by a judge that it's been brought to. But as written and as it applies right now, you don't get to choose. You know, it's like everyone drives 75. I'm going to drive 75 because 55 or 65, whatever it might be, doesn't apply to me. It's not how it works. And there are social implications and reasons why we have different laws, and that's what the legislature has decided that the law in Rhode Island should be, and that's what the law is, therefore.
Obviously, the law is there for a reason. It's meant to be serious so that you will take it seriously. So if you either provide or enable a minor to have alcohol, first offense, assuming someone's caught walking out of the liquor store, and never mind that they hit a tree, what's the penalty? Are you, as the adult, admonished? You're fined? Are you incarcerated?
On the criminal side, there would be a monetary penalty.
Yeah.
And I don't know if it was 6 months probation. I don't think it's a misdemeanor.
It's a misdemeanor. And again, I think, to go back to another point, if children come onto your property and children drink on your property, and you had no reason to know that children are on your property drinking, you can't be held liable under this statute. That it only applies to those situations where you're either furnishing the alcohol and you know, not that the alcohol was there, but that you knowingly furnished it to the children to drink, or you allowed them to drink on your property and you knew or should have known that they were drinking on your property. Because you can't constitutionally hold someone liable for a criminal act unless they intentionally did something or intentionally didn't do something to be held liable.
The key there is intent. You have to prove intent to prove the crime.
And apparently, in that Sarah case that's down in Charahoe, the lawyer who is challenging this is also saying that he has grounds to challenge it because never mind its vagueness or its ambiguity, there was also an issue about whether or not she had some right to search those youngsters if she didn't really see it and it wasn't out in the open, and really how should she be liable in that situation. But then there's another issue, considering you were mentioning that case with Sarah, which was how about the fact that she then left the scene of a crime and was negligent? Is that is that a civil issue? Is that a criminal issue? Is it going to be both?
So on the civil side, if she was negligent and did something that a reasonable person in the same circumstances wouldn't have done and that caused injury, then there can be liability for that. She was also charged under what I'm going to call the Good Samaritan law. It actually reminds me a little bit of that last Seinfeld episode, where if you happen upon the scene of an accident and you can render aid without putting yourself in peril, then you have an obligation to do that. And according to the reports, she happened upon the scene. She said some things, whatever they might have been, derogatory perhaps towards, I knew something was going to happen or whatever, and left without rendering aid. Whether or not that violates that statute is also part of the pending case.
Interesting. So if you are hosting a party and you do see that somehow the underage minors there ended up getting their hands on some liquor and it's in your basement, what should you do?
Tell them to leave, confiscate the alcohol first, and tell them to leave. Call their parents.
Call the parents.
Yeah, call the parents.
Before you tell them to leave, you'd make sure they're not drunk. Because you're not going to send them out on the road if they're impaired.
Yeah.
So if they were there and they hadn't had anything to drink yet, you might tell them to leave. If they've been drinking, then you would call the parents and say, come get your kids or kid or whatever. You need to get them out of here. But you immediately put a stop to what they're doing.
Is it your responsibility if, say, there were 5 or 6, they all are legal age to drive, one steps forward and said, but I didn't drink, I'll take them home.
I wouldn't
Whoops,
take
they
that
fibbed.
risk. Yeah, I definitely wouldn't take that risk.
And so what happens? If that person had fibbed, you trusted them, you let them be the chauffeur, and something happens, they
Well,
ride, are you still liable?
If you, given the facts of your scenario, the way I hear it is the parent didn't know that they had alcohol, they happened upon it. So I don't think you can prove the intent on the civil side that they intentionally served the underage person, but on the criminal side, but on the civil side, that could be a gray area.
Were you negligent in not knowing?
Yeah.
So, I mean, if this kid is presenting to you as perfectly fine, there's no smell of alcohol on the breath, they don't have the indicia, as they say, that a police officer would look for, the signs of
Yes.
alcohol use, then maybe you weren't negligent. But if there's any suspicion and you didn't do something about it, then you could be held liable.
And now thinking of you being social host, and it's Uncle Ernie, who is middle-aged, not 18 or 20, and you see that he's had just a little too much, may not really be seriously impaired, but where should you err? Obviously on the side of caution, what should you do? What would you suggest?
So, Uncle Ernie and all of his friends and your other relatives come over for a Christmas party, and you serve the highly infused eggnog or whatever else it is, and they all get drunk. Under the current status of Rhode Island law, there is no civil liability on the host for serving alcohol to adults. Adults are presumed sort of to be an intervening cause, if you will. They're supposed to take care of themselves and act responsibly and drink only to the level that they can reasonably handle. And there's been several cases in Rhode Island that have all repeatedly said that there's no civil liability for injury to the person who you served alcohol to or to people that they may have injured on their way home. Every case the Supreme Court has challenged the legislature to say, if you want to change this rule, it's up to you to change it. And that's what I was saying. The legislature sways with what the social norms are and what we want as a society. And I have not seen any legislation come out changing liability in that social host situation where you're serving an adult.
Let's talk a little bit about the commercial side of things, whether it's a business hosting a party, at a private home, at a restaurant. What are the rules and regs and do's and don'ts, and how do we avoid trouble?
Well, if you're looking at the restaurant, then you go back to the dram shop laws,
Right.
which is the liability on the part of the restaurant if they continually serve someone alcohol, knowing that the person's intoxicated. With the dram shop law, if the person goes out and then injures himself or someone else, then there is a liability on behalf of the entity. And when I have in court a lot of times when they'll ask, where was the place of your last drink? On the civil side, I think the same, going back to the reasonableness standard. If it's your business that's hosting the party, again, that would be a gray area.
It raises some interesting issues.
Explore.
Okay, so if you have the party at your house, the first question would be are you still covered by the current status of the social host law in Rhode Island that there's no liability because the adult is supposed to take care of the adult themselves? Are they compelled to be there? Do they have to be there for that party? If they're injured, are they entitled to workers' compensation? It says an area of law where there's been several cases on it. If it's a requirement for them to go there as part of their job, they may actually get workers' compensation.
Does anyone ever require that, David?
I wouldn't think in today's day and age you would.
No, otherwise it would be outside the scope of their employment.
If it's outside the scope of their employment, they're not required to be there. It's probably
Good to know.
not going to be a workers' compensation case. On the dram shop side, as Jackie says, if you have the party at a restaurant and the restaurant overserves you, then the restaurant's going to step into the shoes of the person who's going to be liable. And as Jackie said, if they are negligent under the Dram Shop Act in serving someone, they're going to be liable for the damage that that person who was overserved may do to a third party. If they're reckless, if Jackie and I are at a bar and they keep serving us to the point of annihilation, and they know that they're overserving us recklessly, or if they serve a minor, it's considered reckless, then they're liable not only for the damage that that person might do to a third party, but also to the injury that that party might inflict upon themselves.
Does the dram shop law come into play when someone is thinking about having a party at a restaurant or banquet facility and distributes tickets that they've presumably paid for so that you are entitled, David, to 3 and you to 3, and after that, anything else that you have, I've been responsible because you're not having more than 3 drinks at my ticket, and I'm trying to control that and be conscientious. Does that mean then under no circumstances could I ever be sued just because I've tried to take control? Again, you're saying it's the commercial entity that's involved, and that's why many people will have their events at that kind of facility. But then if the facility will continue to serve them, does that mean that entirely it's in their court to shut them off when they need to?
Yes. Exactly, if they know that somebody is intoxicated, visibly intoxicated.
And
Right.
are you made less culpable for having tried to do that, David?
I don't think so.
Okay.
Because if Jackie and I are at that party and Jackie doesn't drink and I have 3 tickets and she gives me her 3 tickets, how do they know I don't have 6 tickets?
They don't.
So they're still responsible
Yes.
under the rules. And we talk about TIPS, which is the process, the program that servers of alcohol are supposed to go through in order to know the signs of over-serving someone being under the influence of alcohol and whether or not they are able to have another drink or should have another drink. The same responsibilities fall upon the server of alcohol in a commercial establishment to make sure that they're not serving someone negligently or recklessly.
And to that point, when you are contributing to the delinquency of a minor, apparently that's an issue. If you manslaughter, if something terrible happens, if there's a death resulting, reckless endangerment, all of these kinds of things, are these all something that would pertain to the commercial entity as well as to an individual if they weren't mindful of who they were letting drink and how much they were letting them drink?
Well, it's ultimately up to the state is to determine what they're going to charge the establishment. So if
The
they have
state?
the district attorney,
Okay.
it's going to
Or
be the
Attorney
DA
General.
or the
Yeah.
Attorney General. So if they believe they have the elements of the crime, then they'll charge. So it is a possibility. Yeah, you can be charged with reckless endangerment.
And again,
other-
you have to look at the facts of the situation. If a child, a minor, or someone under 21 is being served alcohol in a commercial establishment and they haven't followed the rules of checking the ID and doing all the things that they reasonably have to do, that automatically is a presumption that they've been negligent or perhaps reckless in the serving of the alcohol to that minor, which opens up a whole host of other charges as you've enumerated. Dram shop law, however, is not the end of the investigation for civil liability when a restaurant or bar is involved. They can still be sued for common law negligence and other things. For example, if they serve some alcohol and they now know they have somebody there who's drunk and needs to get home, and they could easily avoid an injury to somebody else by calling a taxi cab or something for them, they still have to do that. So it's not just the dram shop law that might apply, it might be common law negligence as well.
And speaking of suits and things that attend or follow up on some of these issues, if someone is injured or killed, does that family of, say it's the child or Uncle Ernie's spouse, do they get to sue you because they think that you might have been negligent as a social host, or sue the restaurant because they didn't shut them off when they think that they should have? Are those all options that come into play?
As long as they have standing to sue. So
Right.
if
And who determines that, Jackie?
well, the law,
statute.
the statute does. So, if David's, David's grandfather couldn't sue because of something that happened to David.
Right. There's
unless he's appointed as an executive of the estate,
exactly.
et cetera. But
in a wrongful
yeah.
death case from Rhode Island, the estate may have the claim,
Yeah.
or the beneficiaries of the estate may be able to bring the action directly. So you have to have, as Jackie says, standing based on that the money, the inheritance would go to you or to your estate, and that's where the
where
rights
that
to
comes
sue
in.
come in.
What about the issue that's deep pockets? Whoever has the greatest likelihood of being able to pay and pay more, they refer to it, you can explain, what is joint and several liability? Two defendants likely to be nailed, but the one who's 99% doesn't have to pay, the one who's 1% responsible has to pay the whole bill?
Well, a joint and several it could be a difference of 50-50, 30-70. That's all going to play out in the civil lawsuit
Between those two
between those
defendants.
two defendants. So
But as to the plaintiff,
Yeah.
One
they're both
and
liable.
99 are 100% liable individually to the person who was injured. So what we're really looking at there, to put it in perspective with this topic, is Uncle Ernie came to my house and I served him alcohol. Under the current state of law, I'm probably not going to be liable. But I might be included in the suit just in case, somewhere along the way the Supreme Court decides they want to change their position on this. If you went to a bar as well, and I don't have a lot of money, but the bar has $1 million insurance policy, even if I was primarily responsible, the bar may pay the whole thing, and then I might be sued by the bar for indemnification or subrogation back as to whatever they paid out contribution, the contribution between the tortfeasors. But again, under the current state of the law, the social host at his residence is not likely to be liable to the adult who was served alcohol.
So we don't really, in the social host at your home having a party, we don't have to worry about that so much.
Not from a civil liability
Civil.
standpoint, but I would always be concerned about my guests and their welfare.
Of
and
course.
whether or not the law could change tomorrow, I would just decide that I'm going to be careful and watch what people are doing at my house, because even if I'm not legally responsible, I think there's a moral obligation to make sure people are okay.
Would you say, perhaps this is a rhetorical question, but if more people were more conscientious and feeling more responsible and vigilant, then perhaps you wouldn't have had to have so many hyper-vigilant organizations wanting to legislate all the time, if everyone was watching the store.
of course.
Yeah, but
But-
there's always those who don't, and because of that, there's always going to be organizations that serve a purpose of trying to make sure the law matches up with where our society is today.
A reasonable thing to do. So if you are having just family gatherings, do you think that we've come so far that we have to be serving apple cider only and water?
I don't think so.
No.
I don't think it's become that extreme. No, not at all.
No, the person who comes to the party needs to know what's reasonable for them. You need to be reasonable and careful in watching what people are doing, but you don't have to. It's not the days of prohibition, so you don't have to worry about automatically there's going to be a problem because I served somebody a drink that's over 21 and is responsible for what they're doing. We're not there.
Perhaps a tad too technical, but I'm going to ask it anyway. Not just with this Sarah case that's in Charahoe, but procuring and furnishing alcohol. Is there a difference, or is that the same thing? If you were procuring alcohol for a minor, I'm 21, you're 18, I went in and bought it. I'm procuring it. I didn't buy it. It's in the car, but you wanted the beer.
That's the furnishing.
Mm-hmm.
That's the furnishing.
Is there any difference in terms of my culpability? I'm the adult, I'm the 21-year-old, and you're not. Any difference
Well,
in terms of the law, the eyes of the law?
There's a separate criminal statute for procuring
Right.
as well as furnishing.
But either way, there's going to
There's
be
still
some culpability.
Yeah.
But does it vary in degrees?
Depends on the statute.
Right. Does it vary? No, not really. If you provide alcohol, whether you've already purchased it and then provided it or went in and bought it, you're still violating the law, and if you're providing it to a minor. So it's really very I think the punishment would be just about the same.
Okay. And one other question relative to minors. Hate to say it, but kids these days are pretty sophisticated about getting fake IDs. Jackie, David, what happens if you're hosting the party and they say, I'm 21, here it is, I'll even show you. Something terrible happens. Now what? Are you liable, culpable, when in fact, were you supposed to do a background check on them? They're in your home?
But then that becomes, again, a little excessive. I think you have to go back to the reasonableness standard that David was talking about earlier. If you have reason to believe that it's a valid ID, I mean, how are we as lay people to know
Exactly.
that it's not a valid ID? We're not handwriting experts or whatever it is.
Or holograph
Experts,
experts if they're doing that?
So, we can't be liable on in
All
that
of those
situation.
levels.
Yeah,
Right.
yeah.
And would that also hold true for the commercial establishment, the restaurant at the
Well, that's
bar?
a little different.
Yeah.
How would they know? They're not they're
they're-
checking IDs, but how would they know necessarily if one is fake?
If there is reasonableness used, if they've done everything that a reasonable restaurant would do, and they made a mistake, but it was like one of those things where they had no way of telling, then there might be some protection on the law.
Criminal.
On the dram shop, on the civil side.
Okay.
And perhaps on the criminal side, if there's, a penalty for serving alcohol to an underage drinker. But you have to look at exactly, what they did and compare it to what was reasonable.
And considering that the kids are so good at getting those kinds of fake IDs, does it make sense that when someone walks in your house and you're planning on serving them, you want to be reasonable? Are you likely to say, let's see your ID,
wanna see
kid,
your
before
ID.
you...
Yeah, and here's some tips for that, because this is what I think a good commercial bartender would do. Look at the ID. Of course you say, so when were you born? Or you might ask how old you are. If it's not a Rhode Island address, what's your address? Go through the information on the ID with them and make sure they can answer it all.
And if you're on the docket for having said, I went through these kinds of questions and they knew the answers cold,
Right.
you are
You've satisfied.
technically, you're off the hook.
Well, I think you satisfy that reasonableness standard.
Right. I mean, if you have an ID of Jackie's and I'm using it and I'm under 21 and they can't
obvious.
tell it's not me,
Something.
then maybe you didn't satisfy the reasonableness standard. Or if the ID says I'm from Toms River, New Jersey, and I say I'm from, what I might ask them is, what county is that in?
Yeah.
Or something that would
Yeah, something
be a
that's
little more
not
vague.
on there that they would have to know. And they can answer all those questions. I guess the issue is, what more could I do?
That would be reasonable. And I guess there's one other question I was going to ask with that, which is if someone is given a breathalyzer or asked to take a breathalyzer test, your current thinking these days is you're out of the car, you should take that breathalyzer, even though they could dismiss those charges. In one way, if you say, I don't want to take that, I'm guilty of one thing, but they have to drop the charge of DUI because they didn't know.
The problem is if you don't have a breathalyzer test, it's much more difficult to prove
Yes.
that there was intoxication. So you have to go through all of the elements,
Okay.
what police officer observed, field sobriety, et cetera, et cetera.
Thank you for watching. We hope that you have a wonderful holiday and a safe one. Thank you for watching Legal Matters. Our discussion of legal matters will continue.